Welcome to Dementia-Friendly Prince George's County, Maryland Northern Sector webinar series for caregivers. Today's topic is Navigating Guardianship, sponsored by Prince George's County Government and the Department of Family Services.
Thank you, and thank you for having me here this evening. So as she mentioned, we're going to be discussing guardianships this evening. I have a little presentation. Don't feel like you have to read the slides. I tend to drift from it. And if you do have questions, please put them in the chat box, and I'm happy to stick around afterwards for a few minutes to answer as many of them as we can. So our first slide here, just talking about how Bird and Bird has stayed open during COVID. We've been very fortunate to be able to do that. We are having people come into the office and complying with very strict COVID regulations, but we've been able to provide for Bowie and the surrounding Prince George's County area throughout this time. So please feel confident in coming and meeting with us for all your legal questions and concerns. Regarding guardianships, there really are two types in Maryland. We have both a guardian of the person and a guardian of the property. Both of these things are ways that the court system steps in and tries to assist folks who are not able to manage affairs for themselves, whether that's anything from communicating with their doctors to making decisions such as how to pay their bills, managing their checkbook. All of those day-to-day living decisions that many of us seem to do without any issue and oftentimes take for granted. So who is involved with the guardianship process? You have the alleged disabled person. This is the individual who we need to take care of. We have the petitioner. Oftentimes this is a loved one, a family friend, someone who has some sort of relationship with the alleged disabled person. Usually they recognize that there's a problem and they really want to step in and try to help. And so they're going to petition the court to try to get legal authority to take care of that person. The ward is the alleged disabled person after a guardianship has been granted. We also have court-appointed counsel. So that individual is someone that the court system has gone ahead and appointed on behalf of the alleged disabled person. I have many clients who come into the office and they are looking to become a petitioner. And so I will oftentimes serve as the attorney for the petitioner. I will help them craft their petition and go through the guardianship process. That is different from the court-appointed counsel. We have other lawyers in the office, both Joshua Winger and Timothy Leahy, who often serve as court-appointed counsel. These are just generally independent lawyers throughout the county that the court says, we want you to go meet with this alleged disabled person. Go ahead and talk with them. Gauge for yourself whether you think that they need a guardian. What their thoughts are about who should be their guardian if you think a guardianship is appropriate, and report back to the court with what you have found out. And we'll talk about that process a little bit more. It is required part of the process. I know Mr. Leahy had a case recently where it was truly just to go to the hospital and confirm that somebody was in fact in a coma. And you had to come back and report to the court, yes, this person is in a coma. I laid eyes on him myself. I tried to communicate with him. I spoke with the doctors about his condition. So that is really the role of the court-appointed counsel, is to be someone independent from the petitioner and the petitioner's counsel and try to act for the interest of the alleged disabled person. Then we have the interested persons. These are all the folks who should get notice that this guardianship proceeding is going on. My folks live over in Bowie. My sister lives up in Crofton. If something happened to one of my parents and my sister thought that, hey, I really need to go and file a petition to be guardian over mom or dad, I would be considered an interested person. My sister would have to notify me that she was doing this. Interested people can include family members. It can also include the individuals or institutions that are providing for the alleged disabled person. So it may be something like a skilled nursing care facility, an assisted living facility, a Government program such as Social Security is oftentimes notified because they're going to be interested in who is going to be responsible for that individual's care and or money. So who can be guardian? I mentioned just a moment ago the idea of an adult child being guardian. My sister, for example, being guardian for one of our parents. Really, it is the folks you would expect who have priority to be guardians. And we have that list here on the slide. The spouse, the adult children, parents, adult siblings, the care providers, as we mentioned. But the highest priority is if the alleged disabled person, when they were healthy and able, named a power of attorney. A power of attorney, as long as it's validly executed, is always going to have the top priority to be guardian. And we'll talk a little bit more in just a few moments how powers of attorney intersect with guardianships, but they really are the top priority. And that is all the more reason if you use powers of attorney, it is good to keep them up to date. It is not unusual to have a married couple name each other as powers of attorney, that marriage to end in divorce, and for the individuals not to update their power of attorney. And we see an ex-spouse being named as power of attorney and having a fair degree of high priority in that guardianship proceeding. The courts do try to navigate that in the interest most appropriate for the alleged disabled person, but it does happen. So it is very important to be aware of who the power of attorney is and knowing their standing within the guardianship proceeding. If there are none of these individuals or none of these individuals are fit to serve as guardian, oftentimes it can be, as I mentioned, the assisted living facility, the nursing home, somebody from the county department of aging. I've worked with a number of folks with Prince George's County Department of Aging who serve as guardians and who go and nominate other attorneys and individuals within the county to serve in that role as a guardian. So how does this process really happen? What does someone have to prove to obtain a guardianship, and how does that work? And I will tell you, if you look at this slide and you see judges or law professors, they'll kind of cringe at this slide a little bit with the numbers that I use in here, and it is just sort of the way my mind works. So there are different burdens of proof in the legal sector. The one that we see here in this presentation, we have the preponderance of the evidence, or more likely than not. And I give that, something is 51% more likely versus, 49% likely. That's the preponderance of the evidence. The next is the clear and convincing standard. And that's pretty darn certain, pretty darn likely of something. You're convinced by the evidence that something is pretty likely. And then we have the highest standard that we hear about all the time in TV and movies and on the news, and that is beyond a reasonable doubt, that criminal standard that says you're almost completely certain of something, and that I give the 99.5% certain. And the reason I say judges and law professors don't like that is that 51%, that 85%, that 99.5%, they're going to say those are just arbitrary numbers. They're not really accurate to the legal definition, but it's a good way to conceptualize it in your mind, just as sort of a thought exercise to really talk about how sure we are of something. For guardianships, the burden of proof is clear and convincing, more than preponderance of the evidence, but not necessarily all the way up to that criminal standard of beyond a reasonable doubt. And you have to prove two things. One, that the individual we say needs help, this alleged disabled person, really needs that help. And two, that the person asking to be appointed, the petitioner, they are the person who is best suited to do the job. When the court is making those determinations, they have to decide if someone is competent to continue to make the decisions for themselves. And that often gets talked about in conjunction with the idea of capacity. So capacity is very, very fluid. It's just at that specific moment in time when a medical professional, I use the term doctor there, but there are other medical professionals who are able to determine this, but a medical professional is meeting with someone and says, right now at this moment in time, do they understand what's going on and Are they able to make decisions for themselves? Competency is a judge understanding what the doctors are saying and trying to decide over an extended period of time, does this person have an ability to do it? So capacity, you could imagine somebody has an infection, it's messing with their mind. They go into the hospital on Thursday, the doctor sees them, gives them antibiotics. By Saturday, they have capacity again. The antibiotics did their job, right? They didn't really lose competency there. They just lost capacity for that limited period of time. Competency, we're saying, really, they may have moments of capacity, but over the long haul here, they're really not capable of managing their life, whether it is making healthcare decisions or making financial decisions. And I've differentiated between sort of those two sides of this because there are actually two roles. In the same way someone might create a power of attorney, and they might say, I have a financial power of attorney, and I have a healthcare proxy. We have two different people, one to make healthcare decisions if I'm disabled, one to make financial decisions for whatever the reason. I've just given them that authority. We have that same dynamic with the guardianships. We have the guardian of the person, and this is very similar to the powers and authority of that healthcare proxy. It says this individual lacks the capacity to really make fully informed and capable decisions, and it could be for a lot of different reasons. Maybe it is a mental disease, maybe it's disability, and it talks about things as well as, you know, addiction, which is a big problem that sometimes we need guardianships for. The other stage of that is the court is always going to ask, rather than the court stepping in and appointing someone else this job, is there a less restrictive way to do this? Usually that is the power of attorney, okay? But if we can't do that because the person doesn't have competency to complete a power of attorney, and there's no less restrictive way to get the job done, then the court is going to say, now we need to look at appointing a guardian. The same is true for the property. They say, hey, is there a less effective way to do this? I'm sorry, a less restrictive way to do this, where we really can't do this without stepping in and giving a court order? And is this person really not able to do these things, whether it is managing their home, managing their checkbook, managing their investments, due to a specific disability, disease, addiction? And it also extends to, you'll see in here, the idea of imprisonment. If someone travels abroad and they end up in a foreign jail, you know, they end up in a Russian jail or a North Korean jail or something, that is a form of incapacity where a guardian over their property might be appropriate. While the statute doesn't specifically say we have this no less restrictive alternative requirement with guardianship of the property, that is generally how the courts and lawyers view that, as they say we always should be looking for a less restrictive alternative rather than having a judge step in and mandate an order that somebody else is responsible for an individual's property or their healthcare decisions. So once somebody is actually appointed guardian, what can they do? And the answer is a lot. They really have all of the decision-making authority when it comes to the day-to-day decision-making of someone's life. Do we see a doctor in Greenbelt or one in Laurel? Do we use, you know, Bank of America or BB&T? Do we want to invest in Bitcoin or, you know, Google? Whatever those decisions are, whether you are guardian of the person or guardian of the property, you really have the decision-making authority to make all of those decisions. Certainly, there are going to be some of the bigger decisions that the court's going to say, you got to clear it with us before you go ahead and do it. Those include things like selling a person's home, increasing a person's level of care. So if somebody is in an assisted living facility and we say they really need skilled nursing, or what we used to call a nursing home, moving them from assisted living to assisted living, you don't necessarily need court approval for. Moving them from assisted living to a nursing home or a skilled nursing care facility, you're going to want to have that cleared with the court before you do it as a guardian. The other thing is that a guardian really is in many ways an agent of the court system here. They want to supervise what the guardian is doing. So once you're appointed guardian, the court is almost always going to set out a scheduling order to say, hey, in the next 90 days, 60 days, 30 days, we want to know what this individual has in terms of their property and assets, where they're living, what their diagnoses are. And then once we have approved that, each year thereon, you got to tell us what you're doing with the money. Okay, you can't just be lining your own pockets with it or running off to Tahiti with it or something like that. You are truly responsible to be a fiduciary, a caretaker of that person and their assets. And the court is going to have some supervision over that. The guardianship process is not something that is easy to navigate or something that can be done very quickly. I often tell people who are a little bit reluctant to do powers of attorney, I say, hey, we can turn out powers of attorney in about a week or two and fairly inexpensively. Whereas if you don't do a power of attorney and you end up having a loved one needing to petition for guardianship over you, it usually takes months to get through that process and can be very, very expensive. I will say in Prince George's County, Upper Marlboro does a very good job about trying to process these cases. They usually have a regular Guardianship Friday once a month, and they move these cases along very quickly. And even in a very efficient court like Upper Marlboro and Prince George's County, it usually takes, 60 to 90 days to get through that process. How does that process go? Well, someone first has to file a petition, and there's a whole list of things you got to comply with that they're going to want to know and see in that petition. And usually talking with a lawyer, reviewing the statute, there's a whole bunch of stuff. They want to know what assets the person has, who the interested people are, all this stuff that goes into the petition. Included with the petition are physician certificates. Maryland has statutes for these. You can't just go to a doctor's office and ask for one. You have to use the Maryland form, and it's about 7 or 8 pages. And you have to take these certificates to the alleged disabled person's doctor. You need 2 of them. One has to be a physician. Preferably, we have a second physician, but if you have trouble getting that second physician, you can use a licensed social worker or a psychiatrist to do that as well. And those physician certificates have to certify that, yes, the patient really is in a circumstance where they likely need a guardian. So it's not just, whomever walking up off the street saying, Tony Pasciuto needs a guardian. They're saying, Tony Pasciuto needs a guardian, and his doctors agree with that. Here are these physician's certificates. Once the clerks get that information, it's reviewed, and they approve that petition, that is when the judge appoints that attorney independently to go meet with the alleged disabled person. And that can take some time, particularly during COVID, trying to get into an assisted living facility, to get into a skilled nursing facility, to get into a hospital, or even to get into someone's home and meet with them safely and try to have a conversation with them, judge their capacity for yourself, and make some determinations about whether you think the guardianship is appropriate. That is a difficult thing to do. The other thing that happens is once that petition and those certificates are filed, you have to give notice to the interested persons. And the rule actually says for that notice that you have to not only mail it to them by regular mail, but you have to mail it to them by certified mail, return receipt requested. And so I get more questions about that than anything else in my job. We file these petitions, we mail all of the mailings twice, and I get phone calls saying, I got this, but you sent it to me twice. Why did you send it to me twice? And the answer is, that is what Maryland's rule requires, that you have to give notice to the interested people. The obvious sort of concern with that, and I'll pick on my family again, is if my sister is petitioning to be guardian over my mother, the court really wants to make sure that I'm aware of that. Hopefully everything is on the up and up, but if I'm aware that my sister, and really probably be the other way around, but that I was aware my sister, had huge gambling debts and she's just trying to get access to mom's money through this process, they would want me to know that, because the court's not going to have that information. Only I am. And I would be given an opportunity to say, hey, court, really, it shouldn't be my sister. It should be myself or someone else. So that is why that notice requirement is so strict. With that, we also send out an advice of rights, and this goes to the interested people and to the alleged disabled person saying, hey, this process is starting, and these are the legal interests you have at stake, and you have a right to chime in and say how you feel about this process. Even if you don't want to do the job, just to say, hey, court, the person who's asking really isn't a good person to be doing this. The next thing that happens is that court-appointed attorney has to file a written answer, and they have to tell the petitioner, yes, I think this guardianship's appropriate. No, I don't think this guardianship's appropriate. And also, any of the interested people can also jump in and object as well. Based upon that answer and any potential objection, the court does one of two things. They either issue a show cause order where we simply say, yeah, this guardianship's likely to be approved. The judge just wants to hear from the petitioner and from the court-appointed counsel before the judge makes his or her final call, or they set it in for a trial, and we actually have to present evidence, and both sides have a right to present witnesses and doctors and maybe expert testimony to really see whether the guardianship is appropriate or the person who's asking to be guardian is best suited to do it. Because oftentimes these proceedings involve multiple family members, there is often the idea of whether we should have co-guardians, or what happens if something happens to the initial guardian. Should we have a backup in some way? And I will tell you that this is something that really a lot of different lawyers will give you different answers about. Many lawyers really debate whether the Maryland courts have authority to appoint an alternate or a successor guardian. It doesn't happen all that often, but courts sometimes do it anyway. I had it in one of my cases where a woman who was in her 80s was petitioning to be guardian over her adult daughter who was disabled. And she was very capable, completely able to do the job. But both she and her son thought it would be a good idea to have the son be set up as a backup guardian. And the court said, yep, we'll go along with that. And in the outside chance something happens to mom, the son/brother is already in place to continue on the work. The other thing that the courts may frequently do, more than successor or alternate guardians, is they will appoint co-guardians. You see this a lot for minors. You have a minor, and maybe the minor's parents have passed away, and we need to appoint guardians over that minor. Oftentimes it will be multiple people. Maybe it's an aunt and an uncle. Maybe it's grandparents, something along those lines. Maybe it's older siblings. So co-guardians happens fairly frequently, particularly when it comes to healthcare decisions and being a guardian over the person. The court does seem, in my opinion, to have a preference to have only one guardian of the property. So we only have one person signing the checks, one person showing up at settlement if the house needs to be sold, that sort of thing. But it is done where we do have co-guardians. I will say it is completely dependent upon the circumstances for each individual case, and both having co-guardians or having an alternate or successor guardian really is the exception. And so there isn't really a sound legal advice to say, more often than not, you should always be thinking about a backup guardian and getting that all set up from the get-go. It just doesn't happen that often. And really, you're going to have to show the court a really strong reason why they should go ahead and do that. So I will say, while it's good we have this guardianship process in Maryland, other states may call it a conservatorship. Maryland calls it a guardianship. it's generally not something people really want to do or are excited about doing. And they will say, well, how can we avoid this 3 to 4 month court mess with petitions and notices and mailings and things like that? And there really are two good ways to avoid guardianship. The first is really easy. It is adults should really think about creating both healthcare proxies or powers of attorney and creating durable general powers of attorney. And it really is the adults saying, hey, I don't want to think about getting sick, being disabled, something terrible happening to me. But on the outside chance that I do, I want to be prepared. And having those difficult conversations with family, finding out, which friends, family, professionals, people in your circle are really going to be good at this job and really going to advocate for your desires, particularly on the healthcare side of things. If you have really strong healthcare beliefs, you want somebody who's going to be willing to speak up and talk with the doctor and say, no, doctor, this person didn't really want that. So finding that person and putting a legal document in place before something terrible like a catastrophic stroke or advanced stages of Alzheimer's or dementia or some other awful thing happens to you, that is the best way to avoid guardianship for yourself, and encouraging your loved ones to do that as well. That is a wonderful thing we can all do to really kind of make things easier for our families. I have 2 daughters of my own. If something happened to me, I wouldn't want them fighting over who's doing what and who has the authority to do what in court. It's better for me just to go ahead and make that decision and putting it in writing. The second thing that you can do, and this is really only for the guardian of the property side of things and trying to avoid that guardian of the property, is people can create trusts during their lifetime. And I could talk for hours about all the fun and exciting world of trusts and all the great things that they can do. There's a whole universe of them that can accomplish different goals. But just generally speaking, when you create a trust, you are creating an entity that you could transfer assets to. And then the trust owns that property. You do not. And in that trust, you could say, I'm going to name successor trustees. So my silly example for this is, if I own my house, I can redeed that house, do a brand new deed, and deed it to the trust. And now the trust owns the house, not me. And if something happens to me, I'm in a hospital bed sick somewhere, I don't need a guardian over the property of the trust, because in that trust, I have already named a successor trustee to manage that property. So that would be an example of a less restrictive means of managing the house. Or somebody who is having, say, early diagnoses of dementia or Alzheimer's, doing the powers of attorney while they still have a lot of good days and are healthy and capable, that is a wonderful way to avoid the guardianship process. I mentioned before that I'm going to sort of talk about how guardianships and POAs and trusts all sort of intersect, and they really do. I mean, estates and trust lawyers, elder law lawyers, we all sort of work in this different arena of guardianships, powers of attorneys, and trusts. And really, if you are able to, talking with a lawyer, talking with family and friends, having those really tough discussions, and trying to avoid the guardianship process when you're able to, is a wonderful thing to do.